Let's go to 141, People versus Barnes. Counsel, you want any rebuttal time?
Yes, please, 2 minutes.
2 minutes, sure, go ahead.
May it please the Court, my name is Laura Boyd, counsel for Appellant Thomas Barnes. In 1992, the legislature correctly realized that the then-existing trespass statutes were inapplicable to the common areas of a public housing
Legal Aid
project.
didn't take that position at the time, right?
No, but apparently we were wrong, because the legislature rejected our specific.
Why can't it still be a trespass too after that statute?
Well, it's actually, the deficiency is not actually within the trespass 2 statute. The deficiency is in the element of unlawfulness, knowingly entering or remaining unlawfully.
In other words, somebody who just wandered into a public housing project's common area, there was no sign saying you can't trespass.
Door was unlocked.
And the door might have been unlocked or something like that, and they don't know that they're trespassing. Is that what you mean by the unlawfulness?
That's one of the 3 problems with the information in this case. You have to knowingly, which Your Honor is touching on, you have to have some notice that the building is not open to the public, be it a locked door or something like that. That would apply to private property. It would not be sufficient, however, to charge second degree in a public housing project, and here's the reason why. Both, in 1992 we're talking about, both the third and second degree statutes prescribed unlawfully entering or, knowingly entering or remaining unlawfully in, with respect to the third degree a building, the second degree a dwelling. The legislature realized that the public housing project is public property. So in contrast to this Court's ruling in Graves, which explicitly states private property.
Well, let me ask you this. Would the result be different if the door was locked, if there was proof that the door was locked or that there were clear and conspicuous signs posted or other indicia that the public, that it was not open to the public?
That might have a bearing on the knowledge element, but that would not affect the unlawful element, which is also a problem here. Because it is public property, like the school setting, which is also public property.
What case have we said that this kind of public property, is residential public spaces, open to everybody? Where have we said that?
You haven't. You haven't addressed this.
So do we have to say that right
now? The legislature has said.
So if we disagree with you,
where does it come from? The legislature is saying this is public property. And I'm not saying that it's open to everybody, but I'll get to that. The legislature has said this is public property. The legislature has equated this to school property.
Do we get to the legislature if we're looking at the plain language of the statute? And you were pointing out what are the problems with the plain language of trespass 2 versus trespass 3.
You do get.
We're looking at trespass 2.
You do get to it, and here's the reason why. The unlawful entering or remaining unlawfully has a separate statute which defines it. Penal Law 140 subdivision 5, and it specifically sets out when somebody is licensed and privileged to enter. It says a person who enters or remains unlawfully in a premises when he is not licensed or privileged. The statute then goes to confer license and privilege on people to enter properties that are open to the public, land that's not sufficiently enclosed. But at the very end, where it's dealing with school property, which is public property, it doesn't confer the license and privilege. It withdraws the license and privilege. And the problem the legislature recognized was that statute did not withdraw the license and privilege.
Could the legislature have been wrong?
They're the ones who interpret their own statutes, and they're the ones who said this is public property, like school property. And they're the ones who recognize.
Are they saying we make a legislative we decide legislatively that this is public property, or is it, we believe the law indicates that this is public property.
It's owned by the public. It's a public housing. It's owned by the municipality, just like
I'm sorry, is that in the legislative history you're referring to?
they're saying it's public property, and they're equating it to school property, yes, in the legislative history.
Again, but is that based on the legislator's own pronouncement or an assumption about what they understand the law to be?
That's their pronouncement. That's their, I'm
Where
not
is
clear
it
on
in the
your,
legislative history you're asking me to look for?
excuse me?
Where is it in the legislative history that they are pronouncing, we declare that these lobbies in a NYCHA residential building are open to the public,
Okay, it says,
except for the provision they then pass, right? You've got the no trespassing sign you put on notice.
okay, the legislature said, presently there's a loophole in the law that does not allow housing to police to issue summons to persons on the premises of a public housing project, if they do not reside in the building and are not visiting a resident of the building. The reason for this is because the building is public property. Then they say, just as it's illegal to remain on the premises of a building being used as an elementary.
Okay, it's not, the question is not open to us to say that is an incorrect interpretation?
I would say the legislature's in the best position to decide who owns that property, yes. I would say.
Not who owns, whether or not it's open to the public. We're not talking about ownership.
Go ahead and
Okay.
answer the judge. I'm sorry.
There's two separate things. There's open to the public.
Correct.
Okay? And that applies equally to public or private property, the rules applying to that. If you have a property that's open to the public, you're licensed and privileged to enter the portion that's open to the public. There's a separate question here. Publicly owned versus privately owned property, and the property rights involved. The legislature is saying, and this court has said in Graves, where it's private property, you have to have the consent of the owner to be licensed as privileged. The legislature is saying, and in fact, they didn't just say this in this case, they said this when they made the statute for 140 subdivision 5 regarding school properties. They're saying this is public property and we have to take away the license. They didn't invent this concept for public housing projects. They did this many years before with school properties. They just didn't.
There's a difference between a premises where no one resides and premises where someone resides. So I'm back to my question.
Okay, that is.
Is this court unable to render an opinion as to whether or not a lobby in a residential building of NYCHA is open or closed to the public?
Open or closed as far as indicia indicating the public, however.
Inherently open or closed to the public?
No, a public housing project lobby can be closed to the public. And in fact, the legislature enacted.
My question
I'm not understanding.
My question is actually, is it inherently not public space because it's residential?
No, I wouldn't say that. In fact, if Your Honors
So
look.
where else would I find that
Okay. Support for that proposition. The legislature has talked about public places in the context of public offenses, Article 240, Subdivision 1. And they say a public place means a place to which the public or a substantial group of persons has access. And they specifically say lobbies and other portions of apartment houses and hotels. So they're distinguishing between the lobbies of the common areas of a building as attracting public, members of the public, not every member of the public, but vast numbers.
So
Now,
is it possible that there might be a distinction there, though, between common areas in which there were indicia that the public wasn't allowed, such as locks and signs, versus common areas where that was not the case, where it was open?
well, what the legislature did when they made the third-degree statute was they took away the license and privilege to be in those common areas. And in doing so, they specified what was required.
Why would they make it less of a crime to trespass in a public housing dwelling than in a private dwelling?
I cannot speak for the legislature, but I would suggest that Section 240 of the penal law may provide guidance as to why there's a distinction. They may feel that these areas are less private or more public, and that may be the reason.
Or is it what I suggested earlier, counsel, when you were talking about unlawfulness? Someone who didn't know that this was that they were not supposed to be there because it's public housing, they walk in, there's no trespass sign or they don't see it, and the door was open, it wasn't locked, and so now they're in there and they don't know they're not supposed to be there, so they're subject to having that privilege to be there.
I certainly think that was a consideration as well. That is why they said in order to be held liable for trespasses in the common areas of a public housing project, you have to have conspicuously posted rules and regulations governing entry so that you can tell people what they can and cannot do.
Thank you, Counsel. You'll have your rebuttal. Let's get to your answer. Counsel.
May it please the Court. My name is Sheila O'Shea, and I represent the respondent on this appeal. The lobby of a public housing project falls squarely within the four corners of the second-degree statute.
I was struck by in your summary of your argument in your brief, you said the legislative history reflects a mistaken belief that the second degree did not apply to public housing.
That's absolutely right, Your Honor.
Are you essentially saying the legislature made a mistake?
I am saying the legislature made a mistake, and I think Judge Rivera touched upon it. The underlying premise of the third-degree statute and of my adversary's argument is that publicly owned equals open to the public, and that's simply not the case.
If it's a mistake, I mean, if you're in a public building and you trespass, you're stuck with two, second degree and third degree. But if you're in a private building, it's only second?
That's right, and the prosecutor would have discretion in the context of a lobby of a public housing project to charge the second or the third degree.
That's not unusual. I mean, you often have a lower consequence charge. You know, you meet the elements of both crimes.
That's absolutely right. In fact, under Maddox and Eberle, the prosecutor does have discretion unless the legislature specifically says this is the exclusive remedy. The legislature never said that here.
On what basis would it be 2 or 3?
Well, again, the prosecutor would have discretion. I think the
how
factors the prosecutor might consider would be the defendant's criminal history.
Why is it a mistaken belief, then? I mean, if you're saying there's 2 and they're consistent and in harmony, but you said they made a mistake. That they did make
a mistake, and I'm going to explain why. I think Judge Rivera touched upon it. I'm sorry, Your Honor.
Have to pass the third degree, right?
Excuse me?
You're saying they didn't have to pass that one.
That's right.
But you charge both. I'm just wondering if it's a mistake, and you say this is clearly a mistake, we shouldn't be charging both. Because they're the same statute.
Both are on books.
Because they're the same statute. You're saying 3 is 2.
No, they're overlapping but not duplicative.
Then they're not a mistake.
Well, I just want to, if I may come back to, I think this may answer your question, which is to say that there's a qualitative difference between a building where people reside. There's a notion that where people live and lay their heads at night is kind of a sanctuary from the public. You shouldn't be subjected to the public being at your doorstep. There's a big difference between a residence and the type of public building like a courthouse or a public library or a public park.
Or a school. But what you're saying is if you flip it around the other way, logically, in a public building, there's a presumption of a right to legal presence there. But in a dwelling, while it may be publicly owned, that doesn't mean it's public housing.
That's exactly my point, Your Honor.
So you've got to flip it around the other way, though, and look at the other way, which I think is what your argument is that there's no presumption of a right to legal presence, but to put someone on notice that they don't have a right to legal presence, there has to be the no trespassing sign. The question is, you need to have the locked door. I don't know if that's true.
You don't need the locked door.
How can people come in and ring a buzzer? I mean, there has to be that ability to access that much. So I'm not sure if you do. But
the locked door, I think, is one circumstance which suggests that the property is not open to the public. But here we had various circumstances. We had the fact that the lobby was separated from the street by a vestibule.
You know, there's another argument too, and it's certainly not to either of you as attorneys or as advocates, but there's a fairness argument sometimes, I think, that comes out in these things, is that the people that live in public housing, we should endeavor in our interpretation of the law to make them equal to people that live in purely private housing in terms of some of these basic rights, like being able to walk up and down your stairwells.
That's absolutely right.
That's the goal. That's, I think that was a legislative goal in trying to clarify this loophole. contravening that is the criminalization of very, very petty crimes against a variety of young people that create criminal records for them in cases where they probably shouldn't be created. So that's, I think, what we're confronted with.
Well, we don't know, I don't know if this addresses your concern, but we don't know the circumstances of the stop in this case, unlike, for example, Barksdale, which was argued last week, where there was a suppression hearing. So there may have been a legitimate basis for stopping this defendant other than his mere presence in the building.
Maybe you've already answered, so then I'm requesting you to be a little slightly repetitive. Why is it a lesser sanction? If as Judge Fahey states, and I think some of the legislative history certainly is along the same lines, that the legislature is interested in equal treatment to those who live in publicly owned residences and privately owned residences, and why the difference in the penalty?
Because the legislature erroneously believed that the second-degree statute did not, in fact, cover public housing projects.
Why didn't they just amend the trespass?
I think I wouldn't be standing here had they done that, and that certainly would have been nice. And that's why
No, but I get that point. I understand your point that they made a mistake, but that doesn't explain the sanction, as Judge Stein mentioned before. That might explain that you'd try and close the loophole. But if the attempt to close the loophole is to get parity, then why not have the same sanction?
Well, ideally, that's what they would have done, but again, I think it's because the legislature was operating under the
But they could not?
Well, no, but under the erroneous assumption that prior to 1992, the second-degree statute did not, in fact, apply to public housing projects. And this was the attempt on the part of the legislature to restore or establish parity. It was, I would argue, a failed attempt.
Perhaps I'm not being clear. I understand that they're trying to establish parity to the extent that they're trying to criminalize certain conduct that you argue they misunderstood and thought that under the statute that existed at the time did not cover that conduct, right? Sort of being in the lobby of the NYCHA house, you couldn't be prosecuted and convicted for trespass. Okay, so then they try to deal with that loophole and they create a crime or put that conduct into third degree, the crime. But that doesn't explain, again, why, perhaps I'm just not understanding the two of you, why the lower sanction?
Well, because the third-degree statute, perhaps this will answer your question, applies to a building used as a public housing project, whereas the second-degree statute refers to a dwelling. Buildings comprise both dwellings and non-dwellings. So there are types of buildings in a NYCHA housing project that are not dwellings. For example, senior centers, community centers, basketball courts, they're not buildings, but it's an example of a non-dwelling. So there should be a lesser sanction for trespassing in a non-dwelling.
Do you agree that for second degree that you have to do a fact-specific analysis of what the circumstances are? In other words, whether there is indicia that the public does not have a license to be there?
Yes, I do, but I think that was satisfied by the information here because we have the various factors. First, the fact that the lobby is separated from the street by the vestibule. Second, we've got the residential character of the building, which people don't believe that they can simply walk into an apartment building the way they can recline on a lawn in Central Park. It's open to everyone. No one, that's not commonly understood. And thirdly, we did have the no trespassing sign. It was posted, and the reasonable inference from the fact that it was posted is that it was conspicuously posted, because if the sign is posted, it's there so people can read it. There's a sign, I can't read it with my eyesight, but there's a sign posted in the courtroom here.
But the argument...
There are common areas and there are common areas, right? So if I walk into a lobby, NYCHA, private, doesn't matter, and it has the intercom section, which would be, I guess, in the way you both described it, the outer vestibule of the common area, of the lobby, the entrance, the common area, right? That I think, despite what you've just said, someone would understand that that means it's open to the public, because the whole point of the intercom system is for someone who's not a tenant or otherwise who has access, who can get in, to be able to get an access.
Well, a buzzer system, I think, would imply that the area was not open to the public, that you had to be admitted by a resident.
So what I'm saying is all parts of the building are not necessarily, simply because it's a residential building.
No, and I can
doesn't imply that it's
not
open to the public.
I can see that, Your Honor. I think in this case, based on the allegations and the information, the vestibule would probably not be considered closed to the public.
Isn't that part of the defendant's point? The accusatory instrument here fails to allege knowing unlawful entry into a property that was not open to the public. In other words, you make the distinction between public and dwelling, and I get that. But don't you have to allege that it was a dwelling and not just a public?
Well, it did say, it did in fact, the information did in fact say it was a residential apartment building.
Well, yeah, but it didn't say he was trespassing in the dwelling part.
Well, it said that he was observed beyond the no trespassing sign in the lobby, which is beyond the vestibule.
Right.
And again, those to me are indicia that this area was off limits to the public.
So you're saying that a public building, that the lobby in a public building is off, is off?
Yes, given the factors and the allegations in this complaint, I am saying that the lobby was not open to the public given the circumstances alleged in this information.
Counsel, I got your point about NYCHA buildings, including dwellings and non-dwellings. But the justification to the enactment penal law, the third degree trespass statute says, there's presently a loophole in law that does not allow housing police to issue trespassing summonses to persons on the premises of a public housing project if they do not reside in the building and are not visiting a resident of the building. So that would suggest that they're talking about the dwelling part of the building, not something like a senior citizen center or some other portion of a housing project development that doesn't include dwelling. So it seems that I understand your point that they're mistaken, but they don't seem to be making the distinction that you made regarding trespass 3 and trespass 4.
I don't think that they were, in fairness, but again, I do believe they were mistaken, one of the reasons being that they couldn't cite any precedent to the effect that criminal trespass couldn't be prosecuted.
Well, perhaps it was criminal courts throwing out these trespass, convictions or indictments because they didn't think that these were private dwellings, that they were public buildings, and that's what the legislature was addressing.
Well, my research has revealed only two cases prior to 1992, Rodriguez and Sanders, which are cited in my brief. Rodriguez in particular suggested criminal trespass, the second degree, did in fact apply to the stairwell of a public housing project, which I would argue is analogous to the lobby as a non-private area. In fact, that was the holding, that was the basis for the Court's reasoning that there was probable cause, that this was a non-public area. So, again, I think it was a mistaken presumption or assumption on the part of perhaps a small number of legislatures, and here we all stand as a result. But I think the remedy is for this Court to find that the prosecutor has discretion to charge either.
Okay, Counsel.
Thank you, Your Honor.
Counsel?
It's not a mistake. The legislature said this is public property like school property. And as in where they took away the license in Penal Law 140, Subdivision 5, from school property, they tried to do that with respect to public housing. The commentary to that Penal Law 140, Subdivision 5, specifically states that the legislative intent in the new statute would have been added by the additional amendment to the definition of the term enter and remain unlawfully, indicating in effect that a person who enters or remains in a public housing building, except an open lobby, who is not an employee, resident, invitee, or et cetera, does so without license or privilege.
You mentioned early on in your argument that legal aid had an opinion with respect to this bill at the time that it passed. Is that germane to our discussion?
Excuse me?
Is that germane to our discussion? I mean, didn't you have an opinion?
No, we apparently were wrong because the legislature took into account our input and rejected it. But it's not that you cannot close a lobby to a public housing project. It's that you have to give notice. And it's also not a mistake because the net effect of saying that the second-degree statute is applicable means that the third degree, as it existed in 1992, would also be applicable. It was the identical statute.
Well, that's what I was getting at. I thought that's what you were pointing out at the time.
But the legislature rejected that.
Right.
And, in fact, they created a situation where if you're convicted of the lesser degree crime facing only 90 days in prison, you have to be given notice that you are entering a building that you're not allowed to go into.
Well-
Yet if you're going to be facing a year in jail,
Interpret second degree in the same way?
excuse me?
Could we interpret second-degree trespass in the same way to require some
I
kind of
think the
notice?
legislature could certainly amend the statute, or preferably, as the commentary reflects, amend the definition of enter and remain unlawfully. If you were to amend the second-degree statute on a case-by-case, or analyze it on a case-by-case basis, you at a minimum should provide the same protections to people facing a year in prison as you do to people facing 90 days in prison.
The point
And
being,
that is the notice.
So Shea was pointing out right at the end that they have that discretion, and it worries me that that means because of this person, you say, I could charge him with a 90-day violation, but I don't particularly like this person. I'm going to charge on the same set of facts, so he'll get a year.
And I don't even have to give notice to the person who's going to face a year in prison that he's entering in violation of rules and regulations governing entry of this. And if he walks into an open lobby just to see if there is somebody there who can tell him he's lost, where he's going, he's automatically
Thanks.
May I just make one more quick point?
One very, very, very
We're talking
quick
about
point.
dwellings, and those are aggravating circumstances. They don't bear on the unlawful element.
Okay.
Thank you.
Thanks, Kathy. Thank you both. Appreciate it.